In many parts of the world, employment operates under a system known as at-will. It means an employer can fire a worker instantly, at any time, without providing a shred of warning or a single reason. That system is completely illegal in India. The state strictly requires employers to follow established procedures and provide clear, defensible reasons before terminating an employee. Yet when new hires join the formal sector, they often sign a dense employment contract and mistakenly assume the company holds absolute power over their livelihood. Because of that false assumption, terminated employees regularly walk away from massive legal leverage. They leave mandatory severance pay, accrued leave encashments, and legally owed back wages sitting on the table. Indian labor law is explicitly designed to shield workers from arbitrary firing. It provides an ironclad framework and a precise roadmap you can use to fight back against wrongful dismissal. The foundation of all these protections is the Industrial Disputes Act of 1947, or the ID Act. The ID Act specifically protects a category of employees called workmen. In legal terms, this covers almost anyone performing skilled, unskilled, manual, technical, or clerical work. If you are not in a supervisory or managerial role, taking home more than 10,000 rupees a month, you likely fall under this highly protected umbrella. Under the ID Act, an employer is bound by the just cause rule. To terminate your employment, they must possess a valid, legally defensible reason, such as severe, documented misconduct or habitual neglect of your duties. Even in cases of blatant misconduct, a company cannot simply escort you off the premises. The employer is legally obligated to conduct a formal disciplinary inquiry, and they must grant you an opportunity to respond to the allegations in accordance with the principles of natural justice. Your job security under the ID Act relies entirely on documented evidence and due process. An employer has no legal authority to fire you based on personal bias or a bad mood. If your termination is non-disciplinary, like a company-wide downsizing, you are entitled to strict baseline protections. That starts with a mandatory minimum of 30 days written notice, or the equivalent wages paid in lieu of that notice. This visual shows exactly how your mandatory severance, legally known as retrenchment compensation, is calculated. The law guarantees you 15 days of average pay, multiplied by every completed year of continuous service you've given the company. For large industrial establishments, like factories or mines employing over 100 workers, the law goes a step further. Those employers must secure explicit government approval before executing any layoffs. You can, however, lose these statutory protections entirely. If you commit a material breach of the code of conduct you signed upon hiring, the company can legally bypass these safety nets and fire you for cause. This page from the Tata Group's social media guidelines is a perfect example of how modern policies work. Indian courts have consistently ruled that publishing defamatory or scandalous content about your employer online violates ethical standards and justifies immediate termination. The state heavily regulates an employer's right to take away your job. In exchange, the law expects you to strictly adhere to the ethical and confidentiality boundaries set by your employment terms. So, what happens when a company breaks these rules? Employers frequently attempt retaliatory firings, withhold overtime pay, or deny legally mandated maternity benefits to cut costs. Your first line of defense is the Ministry of Labor's SAMADHAN portal. Initiating a formal industrial dispute through this government system is completely free of charge. This workflow illustrates how the system organizes your claims. You officially log issues, from illegal dismissals to unpaid gratuity, into the centralized SAMADHAN database. Instead of a backlogged court, the portal routes your grievance to a conciliation officer to mediate a legal settlement directly. This digital infrastructure ensures you do not need expensive upfront legal representation to force a massive corporation to the negotiating table. Once you officially enter a formal dispute, Indian labor law grants you a massive tactical advantage regarding the burden of proof. Notice how the scale tips here. The law places the sole burden of proof strictly on the employer. You are not required to prove your firing was illegal. The company must manufacture the evidence to prove it was justified. If the employer refuses to settle and mediation through the conciliation officer fails, you have the right to escalate your case directly to the labor court or the industrial relations court. Judges at this level can enforce severe penalties against companies that violate the ID Act. If they find your termination completely unjustified, they can order the employer to pay you full back wages for every day you were wrongfully out of work. The court can also deploy its ultimate remedy, ordering the employer to fully reinstate you to your previous position, exactly as if the termination never happened. An employment contract in India is a relationship actively guarded by the state. The moment you sign it, the law provides the tools to ensure you are treated as a protected citizen, not a disposable asset.